Hello, folks, and welcome to another episode of Virtual Legality. I'm your host, Richard Hoeg, managing member of the Hoeg Law business law firm of Northville, Michigan. And today we're going to try to hit a few different buttons, do a few different things with the structure of this episode. So if you'll bear with me, I think we can do this a little bit differently than we have in the past. Now, today we're going to talk about one of our favorite U.S. government agencies, the Federal Trade Commission, not about blocking a gaming deal or dealing with horizontal or vertical mergers, but instead with what their regulatory powers are and aren't in respect to some important stuff. And that important stuff today is going to be a discussion of non-compete agreements or non-compete provisions. And if you aren't familiar with that, this is my wheelhouse. And so I thought I would bring up a redacted version of the agreements that I usually draft for this kind of thing in order to explain what this is if you haven't seen one before. But I assume that most people have some notion of what a non-competition agreement or provision is. This is a document called the Proprietary Information Inventions Assignment and Non-Competition Agreement that I often draft a version of for my clients that are onboarding new personnel to work with their company, either in a consulting or employment role. And not all of these look identical, not all of these operate the same, but we can talk about this in broad strokes to discuss what the FTC has done, what you might have seen in the news, and talk about why that should be allowed or shouldn't be allowed based on what the government rules and regulations are. So, with that as background, let's take a look at this PIIA, as I generally call it. And you can see that the first kind of operative provision here is that you'll keep our information confidential, right? We're bringing you into the company. We're going to share some of our secret sauce, how we do things. And because we are bringing you into the fold, you agree that you will keep that information confidential. You won't use it against us. That's kind of the primary first operative provision in an agreement like this one. The next one, which you might also be familiar with, is inventions assignment, right? That's where the PIIA comes from. The inventions assignment is when you make something that we pay for, it will be ours instead of yours, right? And this is a conversation that we have with artists in the intellectual property space, in video games and fan art and everything else all the time. And works made for hire is the concept here. If you are an employee of the company, that essentially when we pay your salary, we are paying for your intellectual output. And if push comes to shove, when we look at what you made, who owns it, that will be us and not you. And some people don't like this, and it's understandable why, because you are creating something out of your own brain, but you are getting paid for that from a corporate side of things. And as a disclaimer, of course, I am a corporate lawyer. That's why I can even bring up a contract like this one. And so take that with whatever grain of salt you want to apply to the notion that I am, in fact, a corporate lawyer, because I'm going to have certain thoughts about how these things operate that other lawyers and other people might or might not agree with. So the goal of a video like this in virtual legality is always to hopefully inform and educate and let you know what you may not know already, or maybe understand better what's happening in the news and things like this around you. But you don't have to take my word for any of this. You don't have to take my word as sacrosanct on these kinds of things. As we'll see towards the end of this video, if you get a lot of lawyers in a room, you're going to get double the amount of opinions on any of this stuff. So we'll see that in force as part of this discussion. But as we continue on, we're assigning the intellectual property. Then we get into kind of the more operative details here. First, we have a non-solicitation or hire of company employees. This says, for your period of service for the company and for a tail period for 1 year hereafter in this kind of redacted version of the document, you won't hire away our employees, which makes sense, right? You're getting relationships that you wouldn't otherwise get if we weren't bringing you on board to our enterprise. You won't steal our people. And to broaden that, you also won't steal our non-employees, right? You're going to have relationships with our contractors, potentially with vendors that are performing services for us. You won't take those people away from us either. And then finally, you won't steal our clients, right? And this does extend past the period of time when you have a relationship with the company on the premise that you will have gained those relationships and they will still be of value for a certain amount of time after you leave our employee or relationship with us. So that's the non-solicitation concepts. Pay attention to those because they probably survive this FTC action, but it's a little bit unclear based on the language that the FTC has chosen to use. And then we get the non-competition provision, the crux of the matter here, the discussion point with the FTC, and that is that you won't compete with us and you won't own any entity that competes with us at the 1% level or higher. And that is for 1 year hereafter. You can have geographical restrictions put on this. An important point to note in the non-competition context is that these provisions and these agreements are already looked at pretty askance by the judicial systems in the various states of the United States, right? So for non-competition, the reasoning has to be that they were gaining access to some secret sauce, some trade secrets, some important information, some proprietary information that is in their brain that they've otherwise agreed to keep confidential, but that we can't really track whether or not they use against you because it is kind of all incorporated into their makeup and their thought processes. So because we can't make that separation, it's deemed to be reasonable by most states in the country that you can protect yourself from being competed with directly for a period of some time after they leave your employ. And that's what this represents. 1 year. Michigan generally will allow term after the period of employment of up to 2 years. Different states have different amounts for that. Different states have different restrictions on what is an acceptable geography for this, whether it's the whole state, whether it's the county in which the employer operates, whether it's all locations where an employer sells goods or services, which can get broad, especially in the internet age. But different states have different rules around these things. One of the most notable of which is that California, a state in the United States, obviously, is a jurisdiction which looks very negatively at non-competition provisions on the whole, and which are generally unenforceable in California in this context, right? So if you are starting a California company, if you're operating in California, if you're hiring people in the video game industry in California, generally speaking, you don't have one of these provisions, or if you do, you try to make it understood that a court can take this out without ripping apart the entire agreement. And California has operated under those premises for a long time. I think probably going back to at least when I was in law school. But it is one thing that if you're a corporate lawyer in the United States, that different jurisdictions have these different rules. California not allowing non-competition provisions was an important one to know. And so reasonable minds can differ as to whether these are successful or not. But as it stands before the FTC's action, how these entities operate, a non-competition provision that is reasonably tailored to what an employee is learning about your company and what geography it attaches to has been deemed to be valid in most jurisdictions in the United States, and not until now seen as terribly anti-competitive or unfair in a competitive sense. And though people don't like these necessarily because they do prevent certain movement of their labor outside of the initial enterprise that they're working for, they have been held to be valid in most circumstances as I described. So that's kind of the context of this. I don't want to scroll too much further because while I think I redacted everything, I don't want to accidentally disclose random bits and pieces online with contracts that I've drafted. So that's a non-competition provision. That's what you see in practice. And certain companies have definitely gone too far with this. We just described how courts are likely to look at these things. Other companies have had them applied to the lowest level workers in their enterprise for longer periods of time, for periods of time that aren't really deemed to be reasonable by the courts, and tried to save them with a provision like this one that we see here that says these are reasonable. And if a court decides that they aren't reasonable, the court can kind of change them and keep the contract in place. But because companies have been doing that, the FTC and others have looked at this kind of structure and said, well, maybe that shouldn't be something that is allowed, which brings us to the Federal Trade Commission Act, right? So this is a section of the law, I brought it up, 15 U.S.C. 45, that talks about what the FTC is supposed to do. And this law says as follows: unfair methods of competition are hereby declared unlawful. Now, notably in this section, unfair methods of competition, the word unfair or even methods or competition aren't really defined. There's a restriction that they have to be affecting commerce. That's called a constitutional hook. That is designed to bring this law under the control of the federal legislature through the constitutional right to make laws regarding commerce, but otherwise really doesn't help inform what the definition is. Unfair methods of competition are hereby declared unlawful is basically all the FTC has to go on. The commission, that's the FTC to you and me, is hereby empowered and directed to prevent persons, partnerships, or corporations from using unfair methods of competition. And this also includes deceptive acts or practices, but that's not what we're looking at here. And so when you look at what the FTC is empowered to do, the primary impetus of their authority, as given to them by the legislature of the United States, is that unfair methods of competition are unlawful, and you guys are going to be the cops that help prevent persons, partnerships, or corporations, entities in the United States from using those unlawful methods of competition. And that's almost all that we've got, but not quite, right? So that's the FTC Act. That is the provision under which they are going to make some rules here that we're going to look at. And they, in another section, they have been granted the power. The commission shall also have the power from time to time to make rules and regulations for the purpose of carrying out the provisions of this subchapter. And you see this exception here that we're going to look at in just a second. But the question becomes, as we look at these things, is this a substantive right to make rules, right? Is from time to time classify corporations and make rules and regulations for the purpose of carrying out the provisions of this subchapter the right to define what unfair competition is, what deceptive acts and practices are. And to make things even more confusing for this particular statutory interpretation question, we have to look at this exception in 57AA2, which says the following: the commission shall have no authority other than its authority under this section to prescribe any rule with respect to unfair or deceptive acts or practices. The preceding sentence shall not affect any authority of the commission to prescribe rules and general statements of policy with respect to unfair methods of competition. So when we look at this, we have some more confusing language that gets added on that says you don't get to prescribe rules with respect to unfair or deceptive acts or practices, but that's not going to prevent you from making general statements of policy with respect to unfair methods of competition. So when we look at an unfair method of competition, as we're going to look at here, the question becomes, does the commission have the right to essentially define this for the legislature? And one could reasonably look at this and say, no, the legislature had the right to define what it meant here, and the act of not defining it was its own kind of political decision that the Congress of the United States made. You don't have to love it. You, in fact, can think it's very weak because Congress didn't want to get into the weeds as to what they were actually making unlawful here. But regardless, if they have the ability to make this law, one can argue that they have the ability to define or not define this provision, and that the commission can't just say what unfair methods of competition are. That's the prospect of the judiciary, right? And to back up a step, if you don't know how the United States political system is organized, we have three co-equal branches of government. One is the legislative, which is the one that writes these laws, right? One is the judicial, which is the one that interprets the laws, and one is the executive, which is what enforces the laws. The FTC here is operating as an executive agency enforcing the laws that are written for it by Congress. And in so doing, they have deigned now to interpret this section here as giving them the authority to write rules defining what an unfair method of competition is, rather than to have the court system interpret what an unfair method of competition is. And there are a lot of reasonable minds that differ pretty profusely as to whether or not that is or should be allowed. So let's take a look at what the FTC said on April 23rd, 2024. This is their fact sheet for their final proposed rule. This would go into effect in a certain number of months after this is proposed. But as we will see as part of this video, it's already been sued over. And I think that lawsuit is likely to have some success. So what did they try to do? The final rule bans new non-competes with all workers, including senior executives. You cannot enter into a new non-compete provision, non-compete agreement after the date that this would go into effect. Specifically, the final rule provides that it is an unfair method of competition, and therefore violation of Section 5 of the FTC Act, what we just read, for employers to enter into non-competes with workers after the effective date. For existing non-competes, the final rule adopts a different approach for senior executives than for other workers. For senior executives, existing non-competes can remain in force. Existing non-competes with workers other than senior executives are not enforceable after the effective date of the final rule. Now, one thing that comes to mind here for me is that not only is this kind of retroactively operative in that whatever contracts are already out there with my clients, with other people's clients, with every company that has a non-competition provision in the United States, that those all coming undone is going to change the nature of the risk profiles that these employers and employees have with each other outside of what was negotiated for. And non-competition agreements can be negotiated for separate compensation. So you already have a kind of takings question with respect to, okay, if I'm a company and I was operating under the laws that existed when I entered into this contract, and I signed a non-competition agreement with somebody that was willing to sign it in exchange for $100,000, and I gave them the $100,000, it doesn't appear to have any mechanism to giving me a refund for that consideration. So can you go and retroactively say now that what I entered into years ago is illegal and has to be rescinded, and I don't get my consideration back, they just get to remove theirs? That's a question in of itself. The secondary question here is, by trying to allow this for senior executives that are not for other workers, you create this kind of grandfathered in secondary tier of companies, right? If you have your senior executives signed up to non-competes now, then you get to keep those. You get that protection into the future. And that appears to me, to my eyes, to be an unbalanced competitive benefit that will not be realized by upstarts and new companies that aren't allowed to enter into non-competes with even senior executives after the rule comes into place. So that seems to be an issue with just the way that this is implemented. They're clearly trying to allow for kind of the broadest strokes of why one would have a non-competition provision, right? A senior executive is the most likely kind of person to have trade secret information, to have secret sauce information at a company. And so the FTC is trying, I think, to play fair with this a little bit, but the way it's implemented might be unwise, because I do think it creates a kind of caste system where if you existed before this went into place, you're going to have senior executives sign up to non-competes, and you can't otherwise match that protection if you're a company that's just coming in right now. And that doesn't seem to be fair to me, but we'll discuss this as we go further into the rule analysis. The FTC estimates that banning non-competes will result in $74 to $194 billion in reduced spending on physician services, 2.7% increase in new firm formation, resulting in 8,500 additional new businesses created each year, and an average of 17,000 to 29,000 more patents each year for the next 10 years. Now, as we already saw with respect to the Microsoft deal and some of the other things we've discussed with the FTC, their estimates at markets and beliefs about how markets will change or be affected by what they do aren't necessarily the strongest. They are, of course, invested with the ability and presumably expertise to analyze markets like this one. But when you're putting forth such a broad policy prescription as banning of non-competes, you are probably, from a political perspective, kind of burdened with trying to make sure that that makes sense to people. And I don't think there's a lot of good evidence, even in what they've put forth in their documentation, which we will look at, as to why this kind of stuff would happen. Worker earnings will go up $400 to $488 billion in increased wages for workers over the next decade. I don't think any of this stuff will really materialize. I say that not because I think it changes how the rules should be interpreted or whether the FTC has the right to do this, because as we saw, they are just interpreting a statutory bit of language. What is an unfair method of competition? And the actual policy prescriptions here, what is positive about what they are doing, aren't important to that interpretation, right? The interpretation really is it unfair? What you should see here is, why are non-competition provisions unfair? And why should we ban them? And we will see some of that a little bit in their actual rule document, but whether or not it's a positive is really outside the ambit of what the FTC is or should be doing, and certainly outside the ambit of whether they can do this, ban non-competition provisions, which is all to say they wrote a lot about it, and they try to justify it from a policy perspective because that's what makes sense in the political environment, but that's not actually what drives whether or not they have the ability to do this. So they say, pursuant to sections 5 and 6G of the Federal Trade Commission Act, that's what we looked at to start this video, the Federal Trade Commission is issuing the non-compete clause rule. The final rule provides that it is an unfair method of competition, and therefore a violation of Section 5. In general, unfair methods of competition are unlawful for persons to, among other things, enter into non-compete clauses with workers on or after the final rule's effective date. With respect to existing non-competes, the final rule adopts a different approach for senior executives than for other workers. For senior executives, existing non-competes can remain in force, while existing non-competes with other workers are not enforceable after the effective date. The final rule is effective, insert date 120 days after date of publication in the Federal Register. So 4 months or so from when this gets published or was published in the Federal Register, this will go into effect, or so the FTC would like it to be. Summary of the final rules provisions. So this is mostly what we saw in the previous document. The Commission proposed the non-compete rule on January 19th, 2023. Based on the Commission's expertise and after careful review and consideration of the entire rulemaking record, so they took comments, the Commission adopts the final rule addressing non-competes. The final rule provides that it is an unfair method of competition for employers to enter into non-compete clauses with workers on or after the rule's effective date. With respect to existing non-competes, we get the senior executives that can still have effective non-compete clauses. The final rule contains separate provisions defining unfair methods of competition for the two subcategories of workers. Specifically, the final rule provides that with respect to a worker other than a senior executive, it is an unfair method of competition to enter into the non-competition clause or to enforce or attempt to enforce a non-competition clause. The final rule provides that with respect to a senior executive, it is an unfair method of competition for a person to enter into or attempt to enter into a non-competition clause, etc. This is basically the same as what we just looked at in the summary. The final rule defines worker as a natural person who works or who previously worked, whether paid or unpaid, without regard to the worker's title or worker status under any other state or federal laws, including but not limited to whether the worker is an employee, etc., who provides service to a person, which is the FTC trying to make worker as broad as possible, right? You heard me describe employees and contractors differently. That's because under U.S. labor law and various state labor laws, those are treated differently. The FTC wants it to apply to anybody that's providing services for anyone else. And that might have its own kind of breadth issues, but you can see what they're trying to get at here, which is everyone involved in providing services will have this ban applied to them. The final rule does not limit or affect enforcement of state laws that restrict non-competes where the state laws do not conflict with the final rule. That's best read as where it's more strict than us, that'll still live, but this rule preempts state laws that conflict with the final rule. And this is going to be another potential fight with various states that want to have a fight with the FTC or the federal government, which is to say, okay, California bans non-competes. That's up to them. They're their own jurisdiction. Michigan doesn't. Michigan now essentially has to enforce this ban by virtue of the FTC saying that it preempts state law when there's a conflict. Is that going to be something that's acceptable to the state of Michigan? Probably Michigan. But other states that have a similar kind of stance to Michigan, that's going to be an open question as well. So why did we do this, says the FTC? And we're not going to read through all 570 pages, folks, I promise. That's a lot of writing, even for the FTC. The purpose of this rulemaking is to address conduct that harms fair competition. Concern about non-competes dates back centuries, and the evidence of harms has increased substantially in recent years. Now, that's probably a problem for the FTC, right? To the extent non-competes have existed for a long time, and they have, the FTC Act coming into effect and then the FTC trying to enforce it as unfair competition now, decades after the FTC Act went into effect, is probably an issue for them, right? When we talk about when a regulation is formed, one of the things that informs whether or not a regulation is going to be legitimate is how the legislature would have thought of the powers that it was conveying to the agency to enforce the statute at the time that the legislation was written. And so if non-competes have dated back centuries, and they have, then the question becomes, is this something that the legislature passing the FTC Act would have seen as unfair competition at the time? And if it isn't, and there's no real suggestion that it is, either in this document or otherwise, then can the FTC essentially take this broad prescription of writing rules and regulations to define unfair competition as something that maybe the original legislature didn't necessarily think it was? And reasonable minds can differ on all this stuff. This is statutory interpretation. This is stuff that gets up to the highest levels of court systems, certainly in the United States, but also in other jurisdictions. And these are not easy questions. So I don't mean to pretend that they are in any respect, but this is a long-standing potential issue. We've seen states and state courts deal with them differently. And now the FTC comes in with a blanket rule that they would see applied to all of the United States. The ability of employers to enforce non-competes has always been restricted based on public policy concerns that courts have recognized for centuries. That's the judiciary branch. For example, in this case in 1711, an English case that provided the foundation for American common law on non-competes, the court noted that workers were vulnerable to exploitation through non-competes and that non-competes threatened a worker's ability to practice a trade and earn a living. Indeed, they are, right? That's why the courts and various jurisdictions have enforced limitations on geography and limitations on term for how long these non-competition provisions can prevent you from going and competing because of those things. These concerns have persisted. Today, non-competes between employers and workers are generally subject to greater scrutiny under state common law than other employment terms because they are often the product of unequal bargaining power and because the employee is likely to give scant attention to the hardship he may later suffer through loss of his livelihood. Now, in fact, I have not noted in either direction that employees give scant attention to the non-solicitation or non-compete provisions in their agreements. These are often the most negotiated things that I deal with, but I'm in a very specific kind of branch of business. I do a lot of startup and tech work, and people are always reading through their offering letters and agreement documents like the ones I showed at the beginning of this video. And so I do think that many folks have greater understanding of what a non-compete could potentially cost them than maybe is thought through by this early court case in the 18th century. For these reasons, state courts often characterize non-competes as disfavored. And I think that's apt. Furthermore, as contracts in restraint of trade, and you might recognize that language as the Sherman Act, non-competes have always been subject to our nation's antitrust laws. And this is probably too broad, right? We talked about the Sherman Act. We talked about the way that it is drafted to basically apply to any contract ever entered into by any party, because contracts are by their nature restraints of some kind or another, and that the courts have enforced the Sherman Act to require an unreasonable restraint of trade. The FTC's obviously kind of had issues with those readings of the Sherman Act, even if they're decades old and precedent setting for a long, long time. And by eliding the kind of notion of what is an unreasonable restraint of trade here, the FTC seeks to have this thought of as something that could be enforced under the Sherman Act. But it's worth noting here, as part of the legal analysis, that the FTC isn't dumb enough to try to make this rule an interpretation under the Sherman Act, right? This is a substantive rule under Section 5 of the FTC Act. We've talked about this in other videos on this channel before. And so it isn't really related to the Sherman Act at all. The FTC is just trying to attach this notion that non-competes are bad to other precedent that they think is helpful to them. The Supreme Court held that several tobacco companies violated both Section 1 and Section 2 of the Sherman Act because of the constantly recurring use of non-competes, among other practices. Now, worth noting in this paragraph is that, as the FTC describes it, this is a part of a broader Sherman Act claim of monopolization and restraint of trade, and that the reason this company got in trouble was because of constantly recurring non-competes and other things that could basically make it unfair, make it problematic in the way that it was being used, right? A blanket ban on something is very different from an as-applied kind of, this is what you're doing wrong with non-competes. You're making them all 50 years. You're applying them to the janitorial staff at your company. None of this should work the way it is. That's unfair competition. We can bring a claim against you. The courts can say, yeah, that's probably right. That's a problem. Thank you, FTC, for bringing it to our attention. A blanket ban is saying even those instances where a state would find it to be reasonable, we are coming on top of that state and saying, no, it is not reasonable for any reason. And so the FTC is kind of stealing a base here, which is worth noting. And certainly the court system and others that are looking at this issue have noted it as well. Concerns about non-compete have increased substantially in recent years in light of empirical research showing that they tend to harm competitive conditions in labor, product, and service markets. And here we have the FTC, very similar to the Microsoft transaction, looking at the antitrust laws and the ambit of authority given to the FTC and perhaps broadening it out a little bit further than either the original legislative intent or what has historically been the ambit of the FTC, which is this notion of protecting labor and service markets, right? Product market is probably not kind of apt here. They're just trying to add that because that is what is more within their wheelhouse. But here, talking about labor changes, being able to protect labor is distinct from the actual entities competing with each other, right? Or to broaden this out to a kind of non-legalese understanding, what is unfair as competing between company A and company B when one or both signs a non-competition provision with their employees? How is that unfair? How is that an unfair method of competition? How is that disadvantaging another party within the competitive environment? And again, like we said in that Microsoft series, the role of the Antitrust Act, the role of the FTC Act is not to benefit given competitors against one another. It is to benefit competition on the whole. So how do these contracts in and of themselves harm competition? And one way you could say it is in the labor and service markets, which is, I think, what the FTC is attaching to here, which is to say that if an individual is restricted from competing with you in some material way, then they're not going to be on the market for whatever your competitor is going to be hiring for. And with that reduction in supply of potential labor sources, that cost to your competitor might increase and otherwise prevent them from competing on a reasonable level with you. But to the extent that the labor price increases, that seems to be something that the FTC is aimed at, certainly in that summary of this rule proposal. So they appear to be coming at it from multiple different directions. It's a little bit hard to see exactly why what they propose here would be unfair competition among the parties that they are ostensibly regulating, right? They're not regulating the workers, they're regulating the companies, and the ambit of authority given to them under the FTC Act is that they can regulate unfair methods of competition. So they have to, at some point, state why this is unfair, not just why it hurts labor markets or why they don't like it, right? And they go for 500 pages here discussing various comments and dismissing the comments that say that they shouldn't do this or that they should restrict it in some way, and backing up the comments that say this is a great idea, which is what you would expect from a document like this. That's fine. But I don't really want to dive too much more deeply into this. I think 17, 20 pages out of 570 is actually enough to give you the lay of the land here. What I do want to talk about is that, as one would expect, they're already getting sued over this. I wanted to look into this lawsuit just a little bit. This is from the Chamber of Commerce of the United States of America, which, despite the lofty title, is not an agency or other kind of group in the United States government. It is an advocacy organization, what you might call a lobbyist group for businesses, small, medium, and large. And they're suing the Federal Trade Commission for essentially not having the authority to do this. All right, so if we scroll down a little bit, because lawsuits are long, we see, recognizing that a company is only as strong as its people, many businesses expend considerable time and resources training and developing their employees. They also allow those employees access to highly sensitive proprietary information. Having invested in their people and entrusted them with valuable company secrets, those businesses have strong interests in preventing competitor businesses from free riding on those investments or gaining improper access to confidential information. For centuries, U.S. businesses have sought to protect those critical interests by entering into reasonable non-compete agreements with their employees. Again, this is obviously the lawsuit against the FTC. These are the people saying that we should be allowed to enter into non-compete provisions, so they're going to gild the lily a little bit here. But certainly, the judicial precedents in America and in general in common law jurisdictions is that there is a version of non-compete agreements, non-compete provisions that are reasonable by geography, by term, and what have you, and that there is a reasonable way to enter into these provisions in order to protect that proprietary information. Many businesses continue to rely on targeted non-compete agreements for these same reasons today. Non-competes typically require an employee to agree, as a condition of employment or in exchange for compensation, that if the employee decides to leave the company, he will not work for the employer's competitors or own an interest in those competitors for a limited period of time thereafter. These agreements benefit employers and workers alike. I'm not entirely sure about the latter. The employer protects its workforce investments in sensitive information, and the worker benefits from increased training, access to more information, and a chance to bargain for higher pay. Now, you always have a chance to bargain for higher pay. I'm not sure the non-competition provision actually enhances that, but certainly there is a level of comfort that especially tech companies and companies that are very much based on the intellectual property secret sauce can have with getting those relationships tightened up through a contractual or other relationship document. And I do think that there is value in that, in making sure that people are willing to hire folks, right? I've got a lot of clients, a lot of founders that are from the get-go very concerned that this idea that they have, this intellectual property that they are generating or developing, is something that could be stolen by a bigger, more robust enterprise. And if they were to do that, then their entire business model would decline. And so they're very cautious about bringing people on as it stands. And I do think there is a chance that if a ban of this type were to be allowed, that they would be more reluctant to hire on strangers or other folks that they don't have an existing trust relationship with. And so I think that is certainly, from a policy perspective, something to think about. But obviously the FTC is not a policy body, right? They aren't elected representatives of the people. They are appointed by various politicians over a course of years, and they are staffed by various people within the executive branch bureaucracy of the United States. So they aren't technically policymakers as described here in this lawsuit or in the other regulations that we've looked at. They are supposed to just be interpreting what policy decisions have been put before them. Policymakers and courts have long understood the benefits of reasonable non-compete agreements. At the same time, they've also recognized that some non-competes may present an undue burden for some types of workers or impose overly broad restrictions. For instance, by preventing an employee from working for a firm hundreds of miles away or many years after leaving a job. And each state has developed its own body of law to strike what it believes is the right balance. At the federal level, by contrast, Congress has never enacted a law regulating non-competes. And without any such authorizing legislation, federal agencies appropriately have never sought to regulate non-competes on a nationwide basis, right? So you can see where they're going with this. They're going to say that the FTC doesn't have the authority to make a rule of this manner. And that brings us back to looking at Section G here, right? They have the right to make rules and regulations for the purpose of carrying out the provisions of the subchapter. Does that give them the authority to substantively write definitions about what these words mean? Or is this more a rule that says, okay, to the extent that you're going to enforce these rules, you can make regulations about how your policies are going to work, what task forces you're going to use, when people have to respond to a notice that you give them, those kinds of more procedural rules and regulations rather than what we would consider substantive rules and regulations. And I think reasonable minds can differ on this, but I tend to look at this provision and say, while it is written very broadly, the intent appears to be that it would be to give kind of logistical authority to figure out exactly how you're going to enforce these things more than what these things are, which appears to be the proper ambit of the legislative and judiciary branches of the U.S. government. But please do let me know in the comments in chat or in the comments to this video later on whether or not you agree with that precept, whether or not you think that the FTC authority granted under the Federal Trade Commission Act is broader than that and should give them the authority to define these things for any and all purposes. That is certainly a position that the FTC seems to be advancing. So you are in good standing with at least one regulatory body in the United States when you look at this. But obviously, this group here believes that that's incorrect. They continue on with their opening gambit here and say the legal authority is restricted. The FTC Act was enacted in 1914. Section 5 of that act declared that unfair methods of competition in commerce are unlawful, and it empowered and directed the commission to prevent entities subject to its jurisdiction from using such methods. Congress removed certain enumerated industries, activities, or entities, such as banks, from the commission's jurisdiction, but otherwise envisioned a commission whose purview would cover commerce across the national economy. The term unfair methods of competition was an expression new in the law when it first appeared in the FTC Act. Congress purposely introduced this phrase to distinguish the commission's authority from the definition of unfair competition at common law. Because the meaning which the common law had given to unfair competition was too narrow, Congress adopted the broader and more flexible phrase unfair methods of competition. Using this new phrase also made clear that Congress designed Section 5 to extend beyond the reach of other antitrust laws, most notably the Sherman Act, whose text did not include the term unfair methods of competition. In particular, Congress wanted the Commission to apply a standard that would reach conduct not captured by other antitrust laws and the rule of reason, which courts applied when interpreting the Sherman Act. Indeed, we've looked at that extensively on this channel, making it impossible to predict with any certainty whether courts would condemn the many practices that seriously interfere with competition. Allowing the Commission to prevent unfair methods of competition would also help the Commission achieve a core purpose of the Act: to stop trade restraints in their incipiency before they grew into violations of other antitrust laws. In fact, this paragraph, despite being in a lawsuit against the FTC, describes the FTC's authority under the FTC Act pretty broadly. By design, the new phrase unfair methods of competition did not admit of precise definition, right? The legislature didn't define that. That's what we discussed earlier. Congress intentionally gave the Commission flexibility to adapt to changing circumstances. The Supreme Court has affirmed the more inclusive scope of Section 5 on numerous occasions and has affirmed the Commission's power under the Act to condemn coercive and unfair practices that have a tendency to stifle or impair competition. Federal appellate courts have likewise consistently held that the Commission's authority under Section 5 extends beyond the letter of other antitrust laws, right? It's not limited to the Sherman Act because that's not the Sherman Act. It's a different section. Congress further expanded the Commission's jurisdiction over time. Congress extended the Commission's authority in 1938 by adding the further prohibition on unfair or deceptive acts or practices. And in 1975, Congress amended the phrase in commerce in Section 5 to in or affecting commerce, a change that was specifically designed to expand the Commission's jurisdiction to make it coextensive with the constitutional power of Congress under the Commerce Clause. Congress gave careful thought to the structure of the FTC as an independent agency entrusted with considerable responsibility. The Commission would consist of 5 members, no more than 3 of whom could be part of the same political party, who would serve for terms of 7 years. The Commission would draw on trained expert staff to develop the body of law regarding what constitutes unfair methods of competition and later unfair and deceptive practices, both through acting as a quasi-judicial body that determines whether conduct is an unfair method of competition in adjudications, and through authority to promulgate legislative rules delineating conduct that constitutes an unfair method of competition. That's the rules provision that we were just looking at. Recognizing that the Commission is an expert agency in making such determinations about anti-competitive conduct, courts reviewing Commission determinations as to what practices constitutes an unfair method of competition have given the Commission's decisions great weight. The FTC Act today reflects a careful balance from Congress. So you can see, even though they describe it so broadly, what the lawsuit is going to try to get to is, okay, so they have this all broad authority, but it's very limited by exactly what the words say and what authority they have. They're not supposed to go outside this because this was a balance that the legislature put forth for them. Congress has directed the Commission to proceed against a broader range of anti-competitive conduct than other antitrust laws like the Sherman and Clayton Acts can reach. On the other hand, Congress has never established a private right of action under Section 5, nor has it authorized the Commission to recover civil penalties or other monetary relief from parties who engage in unfair methods of competition. Instead, the Commission may pursue an adjudication under Section 5B or seek an injunction in federal court under Section 13B against a party that is engaged in an unfair method of competition. So the Act itself talks about what methods that the FTC is supposed to be able to use to go against these unfair methods of competition, and this ban, says this lawsuit, is outside that. The Commission cannot obtain civil penalties or other monetary relief against parties for using an unfair method of competition, although it can obtain civil penalties in court if a party is ordered to cease and desist from a violation and fails to do so. Alongside Section 5, Congress adopted Section 6G, in which it authorized the Commission to make rules and regulations for the purpose of carrying out the provisions of the FTC Act, which include the Act's prohibition on unfair methods of competition. That's what we looked at as well. The plain text of Section 5 and Section 6G taken together empower the Commission to promulgate rules for the purpose of preventing unfair methods of competition. The Commission has exercised its authority under Section 6G to promulgate legislative rules on many occasions, stretching back more than half a century. Between 1963 and 1978, the Commission relied on Section 6G to promulgate the following rules: a rule declaring it an unfair method of competition and an unfair or deceptive act or practice to mislead consumers about the size of sleeping bags by representing that the cut size represents the finished size; a rule declaring it a UMC, that's unfair method of competition, to use the word automatic or similar words to describe household electric sewing machines; a rule declaring it a UMC to misrepresent non-prismatic instruments as prismatic; a rule declaring it a UMC to advertise or market dry cell batteries as leak-proof; a rule declaring it a UMC to misrepresent the cut size as the finished size of tablecloths and similar products. So we see here a lot of kind of false advertising style complaints, right? And we've talked about the FTC's role in false advertising and in declarations with sponsorships and influencers in other videos on this channel. A rule declaring it a UMC to misrepresent that belts are made of leather if they are made of other materials, etc., etc. This continues on for some time. A rule declaring it a UMC to make certain misrepresentations about transistors and radios. And we go for paragraphs and paragraphs and paragraphs. Some of these rules attracted significant attention. For instance, the Commission began the rulemaking process to require warnings on cigarette packages just 1 week after the Surgeon General's landmark report that determined smoking is a health hazard. And that rule was front page news. Following a lobbying campaign by the tobacco industry, Congress supplanted the Commission's regulation with the Cigarette Labeling and Advertising Act, but did not disturb the Commission's rulemaking authority. So, again, this is one avenue that you could take, right? If you say non-competes are bad, but the FTC doesn't have the authority to make this rule because the rules were not written broadly enough in the FTC Act, you could say, all right, Congress, we think non-competes are bad. Get to it, making a non-compete ban at a congressional level. You're the legislature. You have the authority to do this under the Constitution. And that's the kind of thing that has happened historically in the past. In National Petroleum Refiners Association versus the FTC, the D.C. Circuit expressly upheld the octane rule as a proper exercise of the Commission's power under Section 6G to make rules regulating both unfair methods of competition and unfair or deceptive acts or practices. After construing the words of the statute creating the Commission and delineating its powers, the court held that under the terms of its governing statute and under 6G, the Federal Trade Commission is authorized to promulgate rules defining the meaning of the statutory standards of the illegality the Commission is empowered to prevent. That interpretation was also reinforced by the construction courts have given similar provisions in the authorizing statutes of other administrative agencies. Following such rulemakings and the D.C. Circuit's confirmation of the Commission's rulemaking power in petroleum refiners, Congress in 1975 enacted a new Section 18 of the FTC Act. That new section introduced special procedures beyond those required under the Administrative Procedure Act for promulgating rules for unfair or deceptive acts or practices, and it eliminated the Commission's authority to issue such rules under 6G. That's the last bit of statutory code that we looked at here, right? This is the one that says you have no authority other than the authority under this section to prescribe any rule with respect to unfair or deceptive acts or practices, but you're still allowed to make statements of policy with respect to unfair methods of competition, et cetera, right? So we've got a lot of confusing different moves in this particular act because Congress moved multiple times to kind of try to clarify what was happening in the judicial and kind of policy levels. So continuing with this description. Oh, see, I was reading the wrong document. That's why that makes sense. Apologies, folks. This was actually the FTC backing up its authority to do these things, not the lawsuit that we were originally looking at. That's my fault. Makes a lot more sense as to why this lawsuit was so particular about giving the FTC the authority to do these things. But the FTC claims this authority under those interpretations of the act. The lawsuit says, for the first time in its history, the Federal Trade Commission has issued a sweepingly broad rule addressing worker non-compete agreements on a nationwide basis, decreeing that nearly every one of them constitutes an unfair method of competition under Section 5 of the Federal Trade Commission Act. By the Commission's own estimates, the non-compete rule will retroactively invalidate 30 million contracts despite broad enforcement of those agreements under governing state laws. And by categorically banning non-competes going forward, the rule will impose huge costs both on workers and on businesses. Plaintiffs easily satisfy the requirements for an order staying the non-competes rule effective date preliminarily enjoining the Commission from enforcing it, or both. First, plaintiffs are overwhelmingly likely to prevail on the merits because the Commission has no authority to issue regulations prohibiting unfair methods of competition. For decades, the Commission has addressed unfair competition practices through individual adjudications, applying standard antitrust principles to the facts of each case. The Commission now claims that a seldom used housekeeping provision of the FTC Act, Section 6G, actually grants a long dormant power, meaning they've never used it before, to issue substantive rules declaring business practices unlawful. The text, context, structure, and history of Section 6G say otherwise. And if there were any doubt, it would be resolved by the Major Questions Doctrine, which recognizes that Congress must speak clearly if it wishes to assign an agency decisions of vast economic and political significance. We're going to talk about major questions a little bit more in a second. I want to make sure I clarify the competing kind of interpretations of these provisions. So the FTC says all these provisions together give it this authority. As the Seventh Circuit later put it, Congress considered the controversy surrounding the Commission's substantive rulemaking power under Section 6G to have been settled by the Octane rating case. And so they think that they have the authority to make these substantive decisions. But I think reasonable minds can argue certainly that they have not made substantive rulemaking like this. It was really more focused on that kind of false advertising concept before. Both the 1975 and 1980 amendments to the FTC Act thus indicate that Congress understood the Commission possessed rulemaking power under Section 6G and chose to leave this authority in place. So the FTC says, okay, 6G looks a little broad. 6G looks like maybe we don't have the authority to make these kind of determinations, but we have in the past, and we're going to categorize these particular kind of false advertising complaints as substantive rulemaking. And because Congress didn't take it away from us, in fact, Congress kind of clarified that we do have the authority to make statements of policy, et cetera, with respect to unfair methods of competition, then Congress could have taken this authority away from us. They didn't. Thus, we have this authority. The lawsuit says, no, that's not how statutes work. Congress didn't give you that authority, and the fact that they have not otherwise taken away from you the authority that you don't have is not indicative of anything, right? And you can see how reasonable minds can differ on both of these things. But that's why I wanted to also talk to you a little bit about Yale. This is the Yale Journal on Regulation. This is an article entitled Predicting the Fate of the FTC's Non-Compete Ban by Daniel A. Crane. And as a full disclaimer here, I would say that Professor Crane is one of my professors, right? He's a professor at the University of Michigan. I took a class with him back when I was in school. And so I'm probably predisposed to value his writings on these topics. But that being said, you can value it however you want as we look at this particular discussion of a number of lawyers and legal professionals on this topic. So he writes, the FTC voted 3-2 to adopt a final rule prohibiting non-compete agreements in employment contracts. The two Republican commissioners dissented on a variety of grounds, including that the FTC does not have substantive rulemaking authority under 6G, the major questions doctrine, which we saw referenced, that the rule is arbitrary and capricious, and the non-delegation doctrine. And we'll talk about that one just a little bit here. I want to make sure we talk about most of them. We talked about major questions. That's essentially a new kind of doctrine introduced by the Supreme Court pretty recently in 2022. That is a canon of construction that bars agencies from resolving questions of vast economic and political significance without clear statutory authorization. So the Supreme Court in the United States has been looking at statutes and saying, Congress knows how to write to give you the authority to make broad descriptions of things. And Congress knows how to do this. And if they don't, then you don't have that authority. And so the Supreme Court has taken that up in the last couple of cases. They might well bring it up again. In this case, certainly, I think that banning non-competition provisions across the country and making it effectively retroactively applicable to existing non-competition agreements that may or may not have had consideration change hands is the kind of thing that is a major question, as the Supreme Court has described it. But it's such a new kind of concept and new kind of doctrine from the Supreme Court in and of itself that I don't think anybody can say for sure that any given court in the federal level will decide it on these grounds. It seems to apply, but it's so new that I don't think any lawyer would bet the house on it at this point in time. The other thing that we talked about in that little summary was non-delegation. For those of you that didn't go to law school, this is the concept that Congress cannot take its legislative powers and give it to another body, right? So as we've talked about on this channel, as you've seen on Twitter or social media, wherever you're at, a lot of people look at the United States Congress as effectively broken, that they're not passing laws that people would want, that they're not doing what they are supposed to be doing. And indeed, the legislative branch in the United States has long been a branch that has been criticized for not doing exactly what the people want, et cetera, et cetera. And so one of the things that we saw, certainly in the history of the United States, is that Congress had a tendency or desire to take its lawmaking authority and say, you go handle it, other agencies, so that we can't be blamed for whatever it is that you come up with. And there's a long series of precedent in the United States that says the legislative branch cannot just hand it over to either a future Congress or another agency to go and figure these things out. And so one challenge to this would be essentially at the core of the Federal Trade Commission Act that Congress can't go and delegate such a big substantive rulemaking authority to an agency that's otherwise a part of a branch that doesn't write laws, right? The Federal Trade Commission is a part of the executive branch. It is supposed to execute and enforce laws, not write them. And perhaps this violates that non-delegation doctrine by being so broad as to not be contemplated by the original laws as written by Congress. And those are the order of major challenges to this. You can see that Dr. Crane here went through and talked to a bunch of his friends. How will this all turn out? I went shopping for predictions from scholars of administrative law and antitrust law. 17 people answered, roughly half from the administrative law pool and half from the antitrust pool. Before getting to the outcomes, let me make clear that this isn't anything like a scientific study. Think of this as me walking around a virtual faculty lounge and asking people with expertise for their off-the-cuff predictions. In terms of potential bias, some respondents expressed sympathy for the rule, others antipathy. It seems like a pretty mixed bag, but I make no warranties, so caveat emptor. Caveat emptor here as well. Buyer beware. The question I asked everyone was, is the most likely outcome of the challenge to the rule struck down by the Supreme Court, upheld by the Supreme Court, or never reaches the Supreme Court for any reason, including the Supreme Court doesn't want it, withdraw by a future administration, etc.? Please then feel free to add any commentary, for example, explaining what doctrine the Supreme Court would cite if it strikes it down, why it would uphold, etc. This is meant to be a purely predictive exercise, so please try to be objective. Responses may be quoted, but anonymously, right? So you're talking about academics in law schools and whatnot making these kind of determinations, and so we wanted to provide an anonymous quoting here, so you can take that with a grain of salt, but we have no reason to believe these quotes were not actually made. The results are lots of respondents took the liberty of budgeting my three categories, so I'm not going to try to report the results with numerical precision. Lawyers, right? But almost everyone thought the rule will be struck down, either by a Supreme Court or a lower court. If the nearly unanimous view was that the rule will be invalidated, there was less consensus on the cause of death. The major questions doctrine had a good deal of predictive support. One respondent said, seems like a pretty routine application of the major questions doctrine as to whether the FTC has the rulemaking power it claims to have. A concurring respondent observed that my rationale is that any agency rulemaking that's a big enough deal to make the front page of the New York Times is likely to be invalidated by the courts. Obviously, that's not always going to be true, but it strikes me as a pretty good rule of thumb for the current court. And again, that's part of the discussion here is the politics. We obviously know that the court has been, as interpreted on the political spectrum, making decisions on a more conservative basis, but in a lawmaking and kind of legal interpretation way, rather than looking at it as conservative or liberal or Republican or Democrat, they have been a little bit more against the administrative state's regulatory abilities on these things, right? The major questions doctrine comes from striking down EPA authority, for instance. And so this is the kind of thing that we could look at and say, however we feel about this rule, however we feel about the FTC Act, the real politic is that the current Supreme Court is unlikely to uphold it. I think that's probably right. Supreme Court will not disturb the FTC's assertion of rulemaking authority because, despite its placement, Section 6G is express and broad, and because the court will see rulemaking as generally preferable to adjudication as a means of policymaking. However, Supreme Court will strike down the rule on one of two grounds: either major questions doctrine, because it is retroactive, because the rule affects contracts of 30 million, because contracts are perceived to be largely a matter of state law, or because employment is not the FTC's wheelhouse. They will say that that role belongs to the Department of Labor and the National Labor Relations Board, or constitutional avoidance based on non-delegation grounds. They'll interpret unfair competition to include only product competition and will exclude employment relationships. Another respondent found the FTC's discussion of 6G to be more persuasive than I thought it would be. That's the section that we accidentally read earlier in this video, but thought the court would invalidate by reference to the major questions doctrine, but they might also fashion a separate clear statement rule that applies more specifically to questions involving whether agencies may engage in substantive rulemaking. Yeah, I do think there's a possibility, and this is one of the areas where reasonable minds can differ on the political reasoning behind what the FTC does, that the FTC could actually get burned by precedent here with some kind of court case that says, when we see provisions like this that say, for the purpose of carrying out the provisions of the subchapter, that is an umbrella term used by Congress to essentially allow you to facilitate the overall ambit of the authority that we've given you, such as directed to prevent persons from engaging in unfair methods of competition, not to substantively decide what we meant by all the words that we used in our statute. So I do think there's a real possibility that the Supreme Court could look at this and say, no, none of the provisions that look like this anywhere in our code are designed to give these executive branch agencies the right to substantively rulemaking. That is the purview of the legislature. And to the extent a Supreme Court of the United States might say that, that would really take the fire out from the Federal Trade Commission's belly on these things. So I think that is a potential possibility for the Federal Trade Commission on this, and I think it's something that they should be worried about. But clearly the FTC is operated right now, is operated to stretch the boundaries of what is currently allowed under their statutes. We saw that with the Microsoft transaction attempt at blockage. We've seen that in other things that they've tried to do in antitrust. And we're seeing it here with this attempt to ban the non-competition provisions. Some respondents thought the exact grounds on which the Supreme Court will invalidate the rule are uncertain, even if the outcome is clear. One respondent summed it up: the hard question here is probably not whether the FTC loses, it's how it loses. They explained there are so many ways to challenge the rule that the mind fairly reels. Federal Trade Commission rulemaking authority, unconstitutional removal protections, non-delegation, major questions doctrine, arbitrary and capricious standard. That's the administrative rule that says you're not allowed to just make rules that are arbitrary and capricious in their application. Plus, the rule's novelty make it a ripe target. Whatever you think about Lena Khan or the rule, she's thoroughly alienated conservative legal elites who see the current FTC as an activist, out-of-control agency. I don't think you need to be a conservative to think that the FTC is certainly operating in an activist mindset, meaning that they are trying to set new boundaries. They are trying to establish more authority for their agency than perhaps existed historically or at the time that their statute was entered into. I think they are definitely activists. Whether or not they're out of control, I think is going to be a your mileage may vary proposition. I don't think you really have to be conservative or liberal to see that they are trying to push those boundaries. The justices' constitutional and policy sympathies are likely to be engaged here, which means they're more likely to stretch existing law to stop the rule. The respondent did purport to provide some comfort for the FTC. Contrary to some of the doom and gloom, I do see a narrow path for the FTC. Non-competes are not popular even with judges. Many non-competes arise from bargaining imbalances that seem well within the FTC's purview. The FTC's odds are bad, but I'd give them maybe a 10% chance of winning. So, hey, 10%. So you're saying there's a chance, says this particular legal commenter. And so that's the situation as it stands right now. Can the FTC do this? Well, they have done it. Are they going to stand up in court with this, with lawsuits on the fly? We see from this particular report in the Yale Journal of Regulation that it seems unlikely that they will survive a challenge here. So if you were thinking that you can just tear up your non-compete provisions, I don't recommend it at this point in time. But reasonable minds can differ. Nobody can actually predict what the Supreme Court of the United States, or really any court of the United States, will do with perfect authority. So we've got a lot of different thoughts here. I tend to think that it will fail. This is an overreach by the FTC, but I've thought that for a number of the things that they've done for the past few years, and it's going to take more attempts, I think, by them before they eventually stop trying it. I think the state of affairs is proof, if more were needed, that competition policy is dead in America, if it ever had any meaningful effect, and that the hope of meaningful oversight of harmful and ill-motivated business conduct is gone, probably for the balance of our lifetimes. Good job, America. So that's some commentators here for this particular article. I think it's probably a little bit early to say that. Certainly, you can wait to say that until it gets struck down, but with the FTC moving in this way, I don't think that's the end of any meaningful competition policy in America. In light of my non-scientific findings, here's another non-scientific question. Whatever else they may say publicly, do the 3 FTC commissioners who voted in favor of the rule have a different prediction about the likely outcome in the courts? In other words, do they think, as most of the law profs I polled did, that it's overwhelmingly likely that the rule will be struck down? Or are they making a different prediction, either because they know something I don't, or because they're suffering from self-serving bias? And if they do believe it likely the courts will invalidate the rule, what's the best account of why they're nonetheless going forward with it? They want to do the right thing and be on the right side of history. They want to provoke Congress to give them rulemaking authority or pass a non-compete ban legislatively. It's not certain that the rule will be struck down, and it's worth a try. Something else? And he says we're not likely to find the answer to that question anytime soon. And again, I did say this was a professor of mine back at Michigan Law School, I believe. So take my thoughts on this article with whatever grain of salt you want to apply there. But I think these are all good questions. I tend to think the FTC is acting to stretch the boundaries of what authority it has on the notion that they might get either a partial or entire win on one of these things and essentially seize the ground that they didn't have before all of these efforts were made. Now, do I think that's wise? I don't. I think they are in a judicial environment and even a political environment that is suggestive of them losing rights rather than gaining them by pursuing these particular actions. But I'm not in charge of the FTC, and reasonable minds can differ as to what an institution like the FTC should do when faced with the current political environment and what the ambit of their authority is ostensibly supposed to be. So with that said, that's my opinion on these various things. That's the opinion of a bunch of law professors on these things. What do you all think in the comments? I do want to grab a couple of super chats that I did see fly by. And thank you so much for joining me on today's Virtual Legality. I hope this was helpful, illuminating, and educational. So first, thank you, Just Because, for gifting 10 Hoeg Law memberships. I really appreciate it. Thank you so much. I can't do this stuff without support from viewers and listeners like you. So all that support is appreciated, including in Player and Patreon and memberships and super chats and all of that, including a super chat from Britt here. Hoeg, by accepting the super chat, you agree to the following contract. You will never accept another super chat from another person without saying Britt is great. This is the power of sticky contracts. Sorry, not sorry. Well, I have accepted the super chat because I didn't otherwise go through any other acceptance policy. Is that a contract of adhesion? Is it something that I have to follow through with? I would argue that it is not, because I don't accept separate consideration for the particular agreement. I accepted the consideration for publicizing and getting the super chat itself. But if you want to bring that to me in court, Britt, you're more than welcome to do so. We can have that discussion further on. Certainly, folks that look at non-compete provisions and like what Britt is saying here have a vested interest in acknowledging that contracts are often entered into without equal leverage, and in fact, without even people reading them before they agree to them, right? So I did, in fact, accept this super chat because Google doesn't give me the authority to not accept super chats, and that's its own kind of issue with one of these. But certainly, I am aware enough of the discussion to say you can have a valid good faith argument that non-competition provisions are too broadly entered into by companies, that the people that enter into them aren't in a position of leverage with those companies, and that it is okay for various jurisdictions and policyholders to look at them and say, no, we need to impose some rules on these things, or as in California, that they are void on their face because our public policy says that they are a bad idea. Now, does that mean that the FTC Act that we read through today gives the FTC the authority to do that? I think that is a different question entirely. So, all right. Let's look at some of these comments here. Newspin asks a question. Some federal employees have similar employment restrictions. IRS employees can't get paid for tax prep for a couple of years after leaving the IRS. Is this impacted by this new FTC rule? I would argue that it would be, although I think you could definitely get into an argument about whether they have purview over other government agencies. So when you start bringing in the federal government acting in regulatory capacity over other federal government bodies, you get into other fights that are administrative law based and that I do not have the proper research to get into in detail right here, Newspin, but it is a good question. And I think with the breadth of how the FTC actually kind of defined what a non-compete clause is to mean anything that competes with the entity, and workers to be everybody related to the entity, that it could be read that broadly and it could present a problem for another federal agency. All right. So I do think that that's the kind of thing that might become a fight. There are a lot of fights to be had here. I only brought up one lawsuit. I think there are 3 right now, but there will be a lot of lawsuits and a lot of discussion about whether they have the authority to do this because it affects so many people. And that major questions doctrine might well be at the core of all this, which is to say, can they enter into a regulation with only rulemaking authority that affects 30 million contracts, that affects the entirety of the economy of the United States without a legislative directive to do so? And the FTC argues that they did get that directive, that Congress could have taken their authority away and they didn't. And the lawsuit says, no, Congress knows how to give you authority. They would have given you the authority to look at non-compete agreements if they wanted to. They did not. This is a political maneuver to try to go get more power by the FTC. And I really do believe that reasonable minds can differ on these things. On my side, I tend to think that this is a stretch of what the FTC has historically done and what they are attempting to do here. But I understand why they focused on non-competes first. That's one area where Professor Crane asks at the end of his article, why did they do it this way? I think part of the answer there is in one of the questions that he got answered, which is to say, non-competes aren't loved by many people, right? Even when I went out on social media when this first happened and said, in general, I'm in favor of the freedom of contract rather than the regulatory bodies saying no, I had even friends come into my DMs and say, no, non-competes are bad, we hate them, and they should have something done about them. And so this is a good thing that the FTC is doing. And one of the things that happens with all of this stuff is that we can talk about first principles. We can talk about what the legislative branch is supposed to do. We can talk about what they're not supposed to do at the executive branch. But if somebody does something that you like, a lot of the times, people that are commenting on these things, the public discourse can be on your side, even if you aren't strictly following the rules that are put in front of you, because people like to get things that they like and like to have things that they don't like stopped. And that's just the simple kind of real politic of all this. I understand that. And certainly I think that this was chosen by the FTC because they knew that non-competes are disfavored, not just by the courts, but by the people that have to sign these agreements with non-competes in them, and that there was going to be at least some political backing for this move, even if from a purely legal analysis level, they maybe don't have the authority to do this as they've described. Jenny's getting inky with it. Thank you for the super chat, Jenny. Do you think there's a happy medium where what positions, et cetera, can be considered for non-compete is limited, i.e. limit what positions are considered as requiring a non-compete and the time it lasts? Yes, I do. And I think the various states do that, right? So if we're just talking about Michigan as a for instance, you're only supposed to use non-competes for positions in companies that have some access to that secret sauce. And I'm not getting into the legalese here because I don't think it's important for this discussion, but that have some access to that proprietary information that can't otherwise be protected very easily with a non-disclosure agreement or non-disclosure provision. And with that access, you still can only limit their ability to compete with you to a geography that's close to where they were operating, and for a short amount of time after they leave your employ, right? If you try a 5-year non-compete for the entire country, that's going to be something that the courts in Michigan are unlikely to enforce against that worker on your behalf. So I do think there's a happy medium. I think the common law and the judiciaries of these various states have been working towards that. But I also think that companies can be too aggressive with these things and can put what are essentially unenforceable provisions in contracts on the premise that most people are going to try to be good law-abiding citizens, are going to try to abide by the contractual commitments they sign their name to, and that even if it's technically unenforceable in a court of law, they can use that kind of good nature of people that have worked for them to send nasty grams, to use law firms and lawyers to go and bully them in a way that the court system isn't used for because they wouldn't enforce it themselves, but that a given worker isn't going to know and it isn't going to make sense to fight against because of the cost and logistical effort that the legal system requires. So I do think there's a happy medium. I think it should be publicized more about what is and what is not unenforceable in any given jurisdiction. I'm not sure that a blanket ban with no consideration of what should be reasonable or not is the right idea. In fact, a lot of the commentary that we skipped that you can see being made to the FTC is that, okay, you can enforce some kind of rules around this, but there should be exceptions for senior executives. There should be exceptions for people that are right there making the IP for the company. There should be limitations on geography and time, but it shouldn't just be this kind of blanket hammer cudgel against the entire concept of non-competition provisions. And that's where the FTC is probably going to get into the most trouble with this. But again, they are very aggressive in trying to assert their authority in a lot of ways right now in 2024. So RJ, formerly RJH00, says, I've never heard of fast food restaurants having non-competes. Why would they even do that unless it's purely to harm the worker? Apparently, this is a conversation in the chat. But yes, this is the kind of thing where they are overly aggressive, right? You could say a company, like let's say Kentucky Fried Chicken, and I have no idea whether they have a non-compete, but you know about their 11 herbs and spices, right? And you know of all these conversations in IP land where the Coke formula is kept by 13 different people or what have you. That if you are otherwise being told how this particular company makes their chicken so delicious that you might not necessarily want to have every line worker and every teenager from the local high school have access to that without some protections that it's not going to be made into Alabama fried chicken next door, right? And so you can have these conversations. It would be a very specific fact pattern to get that enforced by a court. And it would be very difficult to do so because it is a minimum wage job and you wouldn't expect them to have access to that. But again, sometimes if you want to run the company in a competitive manner, you want to have people have more access to your intellectual property. You want to run less like a vault or a bank. And at the end of the day, that might be the most competitive, is to have those protections so that you can train employees to the maximum ability, so that you can be as competitive as possible with whatever local restaurant you have next to you. And you can see how either side can fight this from different perspectives and from different kind of incentive structures, how the worker feels about it, how the company feels, how the other companies feel trying to buy workers and their services. And so I think this is one of those areas where I think it is likely to be struck down. I think this is essentially a power grab by the FTC. I think it is done so that they can potentially keep that regulatory authority in substantive rulemaking for other things that maybe aren't as politically well thought of. That the FTC is trying to do here, but I do think it has a good chance, honestly, of blowing up in their faces, which is what has happened with other FTC actions on the antitrust side of things, as we saw with Microsoft and we've seen in other instances. Aldo says, I'm thinking it may be a lawyer that is using a boilerplate employment contract for all their businesses, which includes a non-compete clause. That can also happen, right? When you've got the lawyer that primarily does estate planning, but knows that this employee needs to have some kind of provision to back them up and is doing an onboarding to help their cousin or just because they need the work, you do have kind of a lesser understanding of some of these more common law principles. And you have lawyers that specialize specifically in labor law, because this is one of those areas that is fraught in the United States and other jurisdictions. And so that can happen where somebody's just not as keyed into some of the important stuff here. Sarah R. Hoeg, I'm going to be replay crew, but I'm an hour behind due to internet issues where I am. I also wanted to express a concern about non-competes. Please note I've missed most of the conversation. Sure, Sarah R. We will see what you have to say. You can absolutely express a concern about non-competes. I understand that a lot of people don't like them. I also understand that I draft them, and I'm of a specific perspective as to their usefulness that maybe folks don't see, and that's one of the reasons that I wanted to discuss them with you. But I also wanted to talk about the function of the executive branch, how the FTC operates, and whether or not something that looks like a broad rule should give them the authority to substantively rulemaking like this. RJ, formerly RJH00, says, my question, if this would apply to wrestling. Wrestlers are independent contractors and aren't allowed to appear on a competitor company before 30, 60, 90 days after they leave one company. This provision, the ban that the FTC proposes would be covering these kinds of things. Yeah, the difference between employees and independent contractors is, at least as asserted by the FTC, unimportant. And that if you are providing services for a company, they aren't allowed to enforce a non-compete against you after the day that that rule were to go into effect. And for most wrestlers, as it stands right now, even if the rule doesn't go into effect for 4 months, if they entered into a non-compete right now, it wouldn't be enforceable after that rule went into effect, regardless, because they aren't senior management of the company. They aren't making policy decisions for whatever company they are wrestling for. Presumably, I'm guessing, right? There might be a wrestler out there that helps actually operate their league, but based on what you've just described here, yes, this is the kind of thing that would be prohibited by the FTC. Sarah R., I went to school for automotive, trained in everything there. I was recruited by a shop that had a non-compete. This was 2008. Automotive was hit hard by the recession, was laid off, could not work, and ran into financial issues. And yeah, I think that's horrible, right? And certainly as a lawyer in mid-Michigan, I am very familiar with the automotive industry, and I'm very familiar with the problems that we had in 2008, 2009, and I'm very sorry to hear that. Yeah, I think that's a problem, right? Non-competes can have that happen to the extent that it prevented you from working entirely. That was probably a non-compete that was written over broadly, but I can't speak to it specifically without seeing the language and how it might have been enforced and what roles you had, etc. So I think we can both agree that there are times when it makes a sense to have certain provisions in place that prevent you from using the knowledge and training that you've got to the detriment to the people that would otherwise pay for your knowledge and training. Because if you don't prevent that, then these companies and everyone else is going to be less likely to give knowledge and training to their employees. That's going to hurt the entire economy. It's going to hurt overall welfare in a manner that is completely incongruous with the notions of the Federal Trade Commission Act, the notions of the antitrust acts to keep competition in the economy humming, with the ability of these companies to fight against each other for your dollar. But certainly people can, in different instances, get burned by these things. And I'm very sorry to hear that happened to you. And I can certainly understand why anybody that has had that happen to them would look at these and say somebody should come in and ban these things entirely. But I do think that you can look at this and say there are reasons for these things to exist, and there can be reasonable restrictions on how they are used, but perhaps a blanket ban is a step too far. Jenny's still getting inky with it. And thank you, Jenny, for another super chat. Are there ways the general public can hold these agencies accountable for overstepping their authority outside of lawsuits? The general public would operate primarily through their state attorneys general, I would say. Like if this initial commerce lawsuit doesn't work for whatever reason, you might see it challenged by a coalition of states. You've seen that happen before with respect to rules and rulemaking, and I would suspect that could happen again here. But that's generally how you would do it, right? You don't have a private cause of action under the Administrative Procedures Act to go and challenge the rulemaking authority. If you're directly affected, you might be able to. The general public of small businesses that have non-competes in place could argue that they are damaged by having these things taken away. Like I gave as an example earlier in this video when I mentioned that you could have paid considerable consideration to someone for a non-compete provision that is now no longer enforceable, and that could be seen as a kind of taking, and you could be damaged that way. You could potentially have a lawsuit in that manner against an agency like this, but it would be very difficult. You really bring these to the attention of your government agencies to handle for you. And in this case, the states have attorneys general to fight for their constituents on matters like this. New Spin says, Sarah R., that's messed up. I agree. If you get fired, there should be a provision to release you from the non-compete. I think the FTC is taking it too far, but this is super problematic. Yeah, and there are versions of non-competes and non-solicitation provisions that essentially say if you are let go, then this doesn't apply, or it applies differently, right? The term becomes less, or what have you, or lines up with exactly your severance provision, right? A lot of times, one of the things that I like to do in executive agreements is tie severance and those concepts to whatever the length of non-compete is, and have that compensation kind of mirror that process. So as long as you're getting paid by us, you can't compete with us, that kind of thing. And certainly different clients, different companies, and different entities have different approaches to this. My advice to clients is always to keep it reasonable, really only try to protect what you need to protect as to the investment that you're making in these employees and the access that you're giving them to your trade secrets. But different companies can go too far. And I think this is one of those areas where the FTC has the political backing that they have, because a lot of companies across the country went too far. And because those companies went too far, this is how we get into a situation like this. It's very similar to bad facts make bad law, right? If you've got a defendant that you really hate because he's an asshole or what have you, in court, you can get weird decisions, you can get weird evidentiary procedures and things like that because everybody thinks that they're deserving of whatever's coming to them. And that can create bad precedents. That can create bad situations because the law isn't really supposed to be applied based on whether or not you like the person or not. So I agree that this is an issue that is largely self-created by various industries and various companies. And the FTC is looking at it from that perspective, but that doesn't mean that the United States Federal Congress has actually given them the authority to handle it this way. LawTube subs. Hey, LawTube subs, thank you for the question. The problem is that the main area in which it is abused is against those who can't afford to litigate. That's true. What could be done for those clearly overbroad, but where the employees can't afford court? Well, I think that when you look at places like legal aid societies and other folks that might be recommended by various state bars, these are the kinds of things that those attorneys that are otherwise usually pretty limited in experience can handle, right? The rules in whatever state you're operating in are generally pretty well known because there are enough court cases that have been brought on these premises that you can look at this and say, okay, well, if you're trying to enforce a 10-year non-compete provision for the entire state of Michigan for your tiny fast food restaurant in Ann Arbor, then we can go to a court and say, Your Honor, we need to restrict this to Washtenaw County or Ann Arbor or what have you, and we need to only limit it to fast food. We need to do various things to it, and the court will take a red line and help you out. And that's not the hardest litigation to bring for a legal aid society, and that's what I would probably recommend for those kinds of things. But labor attorneys also handle these things as well, and often do so on a kind of discount is perhaps the wrong word, but expedited basis in terms of legal costs for folks that clearly need it. And I'm entirely against putting unenforceable terms in my contracts. I will advise my clients on these things overall, but not every lawyer is me, not every client are my clients. So I totally understand where the issue comes from, certainly. Sarah R. says she ended up leaving automotive altogether because of this. I don't blame you. There are industries that can create problems like this, and I understand leaving, and I don't blame you one bit. And we have people in the chat saying swear jar. Yes, I did. I used a bad word. Apologies for that. But sometimes I do. Got to use the language sometimes. This Tigerette says here, it was like hearing Captain America say something spicy. Language. I don't mean to, but I thought it was appropriate for that particular usage. And thank you, everybody, for being here in Virtual Legality. I think I've gotten everything on the Super Chat side of things. So I appreciate all of the support. If anybody has any other questions that I have missed, let me know, or leave a comment in this video. Tell people we're having these conversations because I love having them with you. I love doing these things and having these conversations and talks on this channel. And so please do let me know. And I will see you on the next one.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.